I don't know. After hearing him calm and talking about the tether story, it's probable.
Please go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Saturday. Big football day today. If anyone's a fan of Ohio State or Michigan, that game actually starts here shortly. I'm not really a fan of either team. I don't dislike either team. It's always a fun game to watch. My Bearcats play the Jayhawks tonight. It's not going to be pretty. Bearcats are not very good this year. Anyways, let's talk about court. This is a good one. I got two good ones for you. One of them that just happened this morning that I just happened to come across while I was getting ready to run a few errands. So I grabbed it real quick and I'm going to throw it out there. But it might be the quickest bond violation I have ever seen. I'm not going to give it away, but he violates his bond in less than an hour. It's kind of insane, and I would love to hear feedback on it. But the first clip was the original clip I was going to throw out there today, and that was going to be the only one. So you're only going to get one. Now you got a bonus one. Happy Saturday. But before I get into it, you already know what to do. Like and subscribe to your Jump Kick Backflips. And as always, my link tree is in the description if you'd be so kind and to donate. This does take a lot of time to put these videos together. So I appreciate everything. Or you can just watch and hit the like and subscribe button. That's good too. All right, let's go.
Wake up, see. Don't have a case number on us.
Hold on. All right. All right, we're ready.
Okay, on the record in the matter of the people of the state of Michigan versus Eric Welch, file number is 23-03430. Counsel, can I have your appearance?
Assistant Public Defender Sarah Donnelly on behalf of the defendant for the purpose of Raymond Ollywhite, he appears separately from the Lansing Police Department.
Mr. Welch, can you hear me?
No, ma'am.
You can't hear me?
Now I can. Yes, ma'am.
Okay, thank you.
Miss,
Just listen. Just
it's
listen.
important, but before we start,
Just
the
listen.
attorney I spoke with, not my attorney, they wanted me to lie about the day or my address. First thing she said was try to tell me I live somewhere I don't.
Eric.
Hey, just listen. I don't believe.
Okay, Mr. Welch?
Yes,
Mr.
ma'am.
Welch?
Yes, ma'am.
Okay, you spoke earlier with the public defender, okay? I do not want to hear anything that went on in your conversation, okay? Because that's protected information, okay?
It's not my public defender.
You don't own any public defenders, sir.
I know, ma'am, and that
Okay.
public defender asked me to say I live somewhere I didn't, so
Eric.
I can't have that public defender.
Eric.
Okay, well, we can get to the bottom of where you live. I don't see why it would be meaningful for Ms. Donnelly to ask you to say you live someplace where you didn't live. But we'll get to the bottom of your address during this proceeding, okay? Mr. Welch, can you hear me?
Yes, ma'am.
Okay.
I wanna
So,
go to the hospital. I wanna
We
take-
will work on that. Let's get this done first and then we will do that. Just focus, please.
okay. Oh, today's the date, Mr. Welch, set for an arraignment. I have here a misdemeanor complaint that alleges that on or about September 2nd, 2023, at the area of Oakland Ave and June Street, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. The allegation is that you did make an assault or an assault and battery upon a Lacey Rawl, an individual with whom you had a dating relationship. If convicted, restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and up to $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, or an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating the Michigan Compiled Law 750.812 on or about April 22nd, 2003, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814 that will enhance the sentence on the domestic violence if convicted to a misdemeanor maximum penalty of 1 year and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty attached, sir?
Kind of. Yeah, sure.
Okay. You have the right to be represented by an attorney. Mrs. Donnelly from the Office of the Public Defender is here today to represent you only for the purpose of your arraignment. You have the right to have an attorney with you to represent you throughout the pendency of the criminal prosecution. And you also have the right to have an attorney with you to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed to represent you at the expense of the public. Do you understand that right?
Yep,
Is that a yes or no?
yep, yep,
Oh, is that a yes?
yeah, 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 I
Okay,
understand.
thank you. Thank you. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, and you have the right to stand mute. If you stand mute, this matter will proceed to a jury trial, and you have the right to jury trial. You have the right to the presumption of innocence at your jury trial. So that means you are considered innocent, and you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt, and they do that at your jury trial. You understand your rights so far?
I think so.
Okay. Do you have any questions?
Yeah, I would like to know if I can actually have my attorney speak to the attorney that I'll have for this case before so I can fully and intelligently move forward and understand completely what's going on. You know, like to make the best possible decision, because I don't know what to think right now. I don't know what to believe right now.
Okay, yep, you do have the right to an attorney, and you did speak with Ms. Donnelly today.
No, she has me a lot. That's not my
Okay,
attorney.
so you're requesting an opportunity to speak with Ms. Donnelly, or would you like to speak with a different public defender before you move forward with your arraignment?
I would like to speak with somebody who's not gonna ask me to lie.
Okay, she's
Okay.
asking if you want us to talk to someone else right now, or if you want to retain a lawyer later.
As long as they don't ask me to lie.
Okay, that doesn't answer the question. Do you want to talk
Okay.
to somebody
Well,
different right now?
I think I have an answer, so we'll have to reset his arraignment for tomorrow, and then Ms. Donnelly can see if one of her colleagues can come and speak with him, because it sounds like there's a breach of the trust there, and so.
Well, no, Your Honor, I'm the weekend arraignment person too. I've warned him that I didn't tell, and I'm just going on the record. Obviously, I did not tell him to lie. He's misconstruing, and I don't know if he can really understand what's going on. He
You told me I need to give
did
a
say some
different
mental
address.
health. I told you that you're gonna have to live
different
somewhere else. Yes.
Right, that's why. You said you need to tell them you live somewhere different. You can't tell them you live
Okay.
there. That's what you said.
Okay. Well, if you don't feel comfortable with her advising you today, sir, your only other option is to wait until we can get another public defender to advise you, because she's the only, this is a holiday, so we're closed. And so we
Okay.
came in especially and specifically for this purpose. And Ms. Donnelly was available to give you advice. From what my understanding is that the advice, this is a domestic violence, and it's standard procedure that if the address of the the incident, which is the address of the victim, is also your address, then you're gonna need to find someplace else to reside. And
I
it
can do
sounds
it.
to me like
I
that's
can
what
do
Ms.
that.
Donnelly was trying to advise you about. Is that
No.
your understanding now?
No, ma'am, she did not say that. She said you need to
Okay.
write a different address. You need to give the court a different address as to where you have been living. That's what she told me. And I said,
Okay. Well,
I can
we
give
don't-
you an address where I can go, but
Okay.
but I'm not gonna lie about where I've been living.
Okay, sounds good. So what we'll do is, if you do not feel comfortable moving forward with your arraignment until there's another attorney, we can postpone this arraignment. You can find your own attorney, you can retain counsel, or we'll see when you can meet with the next public defender that's available. It won't be today, though.
Okay.
I'm inclined to believe it won't be a different public defender tomorrow, but Ms. Donnelly can advise.
I would like a question for the court.
Yes.
Can we set bond? And
Oh, we won't set bond. We
We can
won't
set
set
bond.
bond until I finish your arraignment.
Okay, we'll finish my arraignment, but we can do
Okay.
it. I don't need a defense attorney. I don't need one to
Okay.
fill in to speak for me as of today. I can speak for
Okay, so you
myself.
you're ready to continue with the arraignment?
Yes, ma'am.
Okay, very good. So did you have any questions about your rights? Because that was the last question I asked you.
I do have the right to represent myself today and then see the public defender at a later time, correct?
Okay, that's your right. You can waive the representation by counsel. You have the right to represent yourself and you have the right to counsel. So that's your right to decide. And you want to move forward today without the representation of counsel? Is that what you're trying to say?
I would like to move forward today without the representation of Ms. Donnelly.
Okay, sounds good. And you have that right to do that. And so she'll be here on standby should that change your mind change, okay?
Yes, ma'am.
Okay, so back to your rights. You have the right to have a trial and you have the right to jury trial. Again, you have the right to the presumption of innocence at your trial. And you have the right to confront in court and cross-examine in court or question in court any other witnesses or the accusers that the prosecutor calls to testify against you. You have the right to call your own witnesses or present evidence at your trial that you believe further a defense to the charge being brought against you. And you also have the right to remain silent at your trial and not have silence be used against you. Do you have any questions about any of those rights?
No, ma'am. I need a hospital.
All right, well, let's finish this and then we'll get you there.
Okay. All right, are you okay, sir?
I don't know. I know I need to go to the hospital.
We will take
Okay, we'll get you to the hospital in just a moment, okay?
Yes, ma'am.
Okay, and so, for the purposes of your arraignment, we're going to enter a plea of not guilty on your behalf. And are you requesting to be represented by a public defender in the future of this matter?
Yes, ma'am. If I can request John Abbott, because he's familiar with me and my situation.
Okay, you can't make a request for a specific attorney, but the public defender's office has their process and they will screen your case and they will assign it appropriately, okay?
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
I don't have a copy of his criminal history for some reason.
So what do we think? Is this guy sick? He's saying he needs to go to the hospital. He seems to understand about half of what's going on. Competency might be an issue. I know the attorney said MH issues. That might be the case too. I don't know. But yeah, she didn't tell you to lie about your place of where you live though. I'm pretty certain about that. All right, let's finish this one up.
Have you ever missed court in the past?
Not as long as I was able. Like, not intentionally. Like, I've had to reschedule court dates before.
Okay, what is your address?
I live at 505 Chilson, but it's my understanding that I'm gonna have to stay somewhere different. But the address is currently 505 Chilson.
Okay, is that the address that Lacey Raw lives?
Yes, ma'am.
Okay, well then you won't be able to stay there during this matter. So where will you stay?
Yes, ma'am. I'm gonna go to probably my sister's house or a good friend of mine. In Holt. The address in Holt will be 4400 apartment 301 Holt Road, Holt, Michigan. If I go to my sister's, it's gonna be
You said
74.
4400 Holt Road?
Yep, 4400
Oh.
Holt Road, apartment 301. But as soon as I'm able, because I haven't been able to call anyone, I'm gonna call him and I'm gonna call my sisters. If it's not there, it would be 74 Langley, Battle Creek, Michigan. More than likely it'll be local, I'll go to Holt, and then if necessary, I'll go to Langley, 74 Langley in Battle Creek, where I'm just not 100% sure everybody's situation, but both places I can go, no problem.
What's your phone number?
I don't know. My phone, it hasn't worked since Lacey picked me up from CMH. I'm supposed to meet my son the next day. We were gonna go make a report about what happened the day I was arrested.
Oh.
My
So you
phone,
don't have a phone, you don't know your phone number?
it don't work.
Okay,
Keep telling me it was one, I don't know.
okay. You're currently scheduled to have a pretrial conference and you're scheduled before Judge Cynthia Ward. It's gonna be on December 11th at 2023 at 10:30 in the morning, okay? Okay?
Okay,
Okay, and we'll get you a copy of your notice to appear. I do not have his criminal history, and so I can't assess, other than the fact that he's being charged as a domestic violence second offense, that there's at least one other domestic violence on his record. Only thing I have before me is the current file, and the affidavit of probable cause. And so based on those things only, I will grant a personal recognizance bond, but with GPS tether. And so bond is set at the amount of 1,000 personal recognizance, and a GPS tether is ordered. You're not to be within 1,500 feet of Lacey Raw. You're not to have contact directly or indirectly with Lacey Raw. You're not to talk over me when I'm talking.
I'm sorry.
You need to make sure you appear to all of your court dates, and you need to appear timely. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. Do you have any questions about your bond?
$1,000 or
It's $1,000 personal recognizance with GPS tether.
okay, so I have to pay it to tell it later. I don't have to give $1,000 to be put on it.
You do not, because it's personal recognizance. You don't have to pay the $1,000. You do have to secure a GPS tether though, okay?
How do I secure it?
If you can't afford to pay for the tether, you would have to apply for assistance to have that covered, okay?
Okay.
Ms. Donnelly, Ms. Donnelly would have more information about how you can apply for that.
Yes, ma'am. Okay, but I'm currently on assistance. I get food stamps and,
Okay, so it sounds like you could potentially be eligible, but you would want to speak with Ms. Donnelly about how to do that, okay?
I don't trust me.
You're just asking her about where you go to apply. You'll have to get that down at Ingham County though, okay?
Yep,
In Mason.
okay, I'll talk to the people there.
Okay, sounds good. Do you have any questions at this time?
No, miss.
You're all set.
Thank you.
Thank you.
Thank you. Thank you. I think that's all we have for today.
I jumped the gun a little bit. I got another one for you. I didn't put them in the same video because I got this one today. So let's watch this one.
1 second here.
All right, this is the thumbnail clip. Quickest bond violation ever. It's kind of wild. And yeah, I do want to hear your opinions on this because this is yeah, it's kind of interesting.
So calling case number prosecuting order 23-10417. This is in the matter of Robert Colin Henley. Detective, appearance for the record.
Detective Zachary Meckley, Your Honor, with Royal Oak.
Okay, thank you. Would you raise your right hand, please? Solemnly swear and affirm the testimony you're about to give is true to the best of your knowledge, information, and belief.
I do.
Okay, please state the facts as you know them in this matter.
Good morning, Your Honor. Detective Meckley with Royal Oak Police Department. Before you today is a 2-count warrant charging Robert Henley, date of birth 2/15/02, with 2 counts of DV third. The facts of the case are documented under Royal Oak Police Department number 23-41064 and are summarized as follows. On November 23rd, officers responded to 4709 Mankota Avenue in the city of Royal Oak, County of Oakland, after being called for domestic disturbance by Claire Henley, which is the defendant's sister. She called and stated that there was a physical altercation between her brother, Robert Henley, and her father, Robert Henley, and that it had escalated to the point where the defendant was now bleeding. Officers responded, found the defendant being treated by the fire department for a laceration to his head as a result of falling and the altercation hitting his head on a door frame. Officers spoke with Robert Henley, the father, who stated that his son had gotten in an argument with his brother John over believing that John had kicked his dog. The two sons began to have a verbal argument. John went upstairs to separate and defuse the argument. The defendant continued to attempt to make it up the stairs and continue the argument when the father stepped between the defendant and his sister, who was sitting on the stairs trying to keep him from walking up the stairs. The defendant grabbed his father by his shirt, began pushing him. The two ended up in a physical scuffle. The father's glasses got knocked off his face and scratched his face while attempting to push him to the ground. The father was able to subdue the defendant, who the two fell on the ground due to his intoxication. The sister attempted to step in and break up the argument again, at which time she was also pushed by the defendant. John, the brother who was upstairs, upon hearing the physical scuffle, came downstairs to see what happened. He observed the defendant assaulting both his father and sister. He shoved the defendant off of the two of them so the altercation would stop. At that time, when he pushed him off of him, is when he fell on his head on a door frame, suffering laceration to his head. I believe this information provided is sufficient to prove probable cause standard in the alleged criminal offense committed by the named defendant. I have affixed my signature to the criminal complaint. Respectfully request the court authorize a warrant in this matter. With that, Your Honor, the warrant's before you.
Okay, the court finds that the alleged crime was committed and that there's probable cause to believe that the defendant committed the said offense. The court will sign and issue the complaint and warrant in this matter. I think the address you indicated was 4709 Mankato?
Yeah, Mankato? Coda?
Yes.
However you want to pronounce it, yeah.
Okay, sounds good, Detective. You can bring the defendant back in and I'll bring his attorney back in as well.
Perfect.
All right. For everyone that doesn't watch Weekend Court, this is generally how it's done. They'll have a police officer read the complaint to dictate probable cause. That's what that was. Doesn't happen a lot during the week. It's already in the report. Yeah, there you go. At least that's my understanding. I could be off.
You can do the arraignment right now. Just go stand where you're standing and we'll just talk to the judge, okay?
And here is our winner. and more downtime. Just a friendly reminder, if you have not liked and subscribed yet, please do so. If you haven't done your jump kick backflips yet, you might want to. Oh, looks like the game just kicked off.
Okay, calling case number prosecutor order 23-10412 in the matter of Robert Colin Henley. Counsel appearance for the record.
Good morning, Your Honor. Nicole Smithson, P71404, appearing on behalf of Mr. Henley for arraignment purposes. I've had the chance to speak with him, advise him of the 2-count warrant, the maximum penalties, his rights. We'd waive reading, stand mute, ask the court to enter a not guilty plea. He is requesting court-appointed counsel moving forward. In regard to bond, he's 21 years old. He's been working for the same landscaping company for roughly 4 years. He does have some traffic matters as well as the 2 prior DVs. Other than that, he has really a nominal history. No health issues, no children. We're asking for a reasonable and small cash surety 10% bond.
Sir, would you, at the jail, would you please state your name for the record?
Robert Henley, sir.
Okay, thank you. Okay, bond in the amount of $3,000 cash surety, no 10% bond. The court does have some concerns with the overriding natures of this. I figure that bond is a reasonable bond. I do have some other conditions, sir. You will not have any direct or indirect contact with the following individuals: Robert Christopher Henley, Claire Henley, John Henley, Danetta Henley, or any other witnesses in this matter. You will not return to the premises known as 415 Mack Avenue in East Lansing, Michigan. You will not go to that location. You will also not return to 4709 Mankato, Mankato in Royal Oak. You will not assault, beat, molest, in any way verbally harass, threaten, or intimidate any witnesses in this matter. You will personally appear for all court proceedings and not leave the state of Michigan without permission of the court. Immediately notify the court in writing of any change of address or phone number. You will not possess any firearms or other dangerous weapons. You will refrain from using alcohol, any form of THC, illegal drugs, or abusing any medication. Court will order that you test 2 times a week for alcohol and drugs. You will be, you must contact pretrial services in Royal Oak at the 44th District Court within 24 hours of your release. Pick up no new criminal offenses. The court will grant court-appointed counsel going forward in this matter. Other than that, sir, your next court date is going to be December the 4th, and you will get a copy of all of this. Your next court date is December the 4th at 9:00 a.m. And you have an exam that is scheduled for December the 11th at 9:00 a.m. Sir, do you understand your bond conditions?
Sir, I do, but I'm asking if there's any way to reconsider. I'm not gonna have my apartment, and I have rent to pay, and I have all this going on, and I won't be able to take care of that. I'm sorry, and I already apologized and said, can you say sorry?
Okay,
for me?
whoa. I think counsel, sir, I think you just need to. So I'm just going to order that you not say anything else, because I don't want you were drifting into the facts of possible facts of the case. So I'm not going to adjust your bond. Your bond is relatively low. There's arrangements you can make.
$3,000 right now. I just paid my rent. I have to pay my rent on the 1st, and I'm not gonna.
Okay. And let me say this. Let me ask you this then. Do you understand your bond conditions first, and then we'll take your question?
Yes, sir.
Okay. Counsel, do you have anything further?
No, Your Honor.
Okay, then we're all set here at the jail.
Thank you, Your Honor.
You're welcome.
All right. This is about an hour later, maybe an hour and a half, maybe an hour. I don't know. But you heard his bond conditions. No contact, right? No contact means no contact. He didn't give him the speech. Who was it? I guess a lot of judges say it. No contact means no contact. No third party contact. That means you can't ask someone else to contact them for you. They didn't go over that. I'm guessing maybe it's supposed to be understood. He probably didn't talk to the attorney in between, but he messed up.
I like fell off my porch or something. Jeez. Hello?
Just wait a second, okay?
All right.
And don't talk.
I meant to unmute and I accidentally hit pause. I do that a lot. Come on, Judge. I'm waiting for you all morning. Need to have some wait music, some elevator music. How old they say this guy was? 24? He looks like he's 18 or 19. But don't worry, it's about to go down. I did love how his attorneys don't talk. The judge did say, let me finish the bond and then I'll answer your questions. And the second he finished it, he's like, all right, we're done.
Again, calling case number prosecutor order 23-10417, the matter of Robert and Colin Henry. Counsel appearance for the record.
Morning again, Your Honor. Nicole Smithson, P71404, appearing on behalf of Mr. Henley. It's my understanding there is an alleged bond violation. We want it set for a full hearing in front of the judge.
Bond violation? I didn't call my mom.
Stop, don't talk, Robert.
Counsel, sir, would you state your name for the record?
Robert Henley?
Okay. Counsel, there is the alleged bond violation. I had just arraigned your client, as you're well aware of, and he was told not to have any contact with several witnesses, including his girlfriend, Alyssa, Alyssa. There, in fact, was a phone call made to her by the defendant shortly after he was arraigned, and that's why we're back in this position.
Okay, his girlfriend is not a listed witness.
She wasn't even there.
I'm looking at the complaint. She is not a listed witness. So there's no, he was not told to not have contact with her. So there's
That's
no
correct.
reason to not have contact with her. That was never told that. And again, he would like a full bond violation hearing in front of the judge.
Okay. Give me a moment, counselor.
Can I just clarify, Your Honor?
Yes, what is his mother's name? Yes, go ahead, and detective, go ahead.
Violate me, bro?
What is your mother's name?
Danette, but I didn't even call her.
Okay.
Robert,
The
stop
bond
talking.
violation was the fact that he used his girlfriend to call his mother and have contact with his mother in order to post bond.
Right, that's what I was.
With his mother for your bond
So-
conditions.
Right, so what's the mother's name?
Danette, dude, why did you
Danette?
violate me for that? That's fucked up.
Robert, stop talking.
I believe is the mother Claire
No, it's Danette Henley.
Danette Henley, which was the order was not to contact Claire Henley, Danette Henley, John Henley, or Robert Christopher Henley. Those were the conditions, and it's my understanding that he contacted, per the information I have before me, he contacted his girlfriend in an attempt to have her contact his mother, Danetta Henley. Those are the allegations that are before the court. So what I'm going to do is that I am going to adjust his bond conditions at this particular point. His bond was set at 3,000 cash surety. I am going to reset that bond at 5,000 cash surety. No 10%.
He has a right to have a bond hearing on this allegation.
And who are you going to have that hearing in front of, Counselor?
He wants to have it in front of the judge, which is also his right.
Well, he can still have the bond hearing. I'm just adjusting the bond.
Okay.
I'm not going to.
So why did you
Deny
violate
him.
me for calling my girl? I wasn't talking
Robert,
to my
stop
mom.
talking.
What is this gonna help me with? They just
Stop-
raised my bond.
stop
That doesn't
talking.
help me with
Robert.
anything.
Stop, let them finish their procedure.
They can finish their procedure. I'm gonna go back
Stop
there and I'm gonna
talking.
have to pay more money.
Stop talking.
So it doesn't make a difference to
Stop
me.
talking.
I called my girlfriend so I could have money brought up here. I
Robert,
need to talk to
stop
my mom.
talking. You're not helping yourself.
Call my girlfriend to have money brought here, dude.
Okay. So
Yeah, I had a little bit of a hard time.
So why did you
Deny
violate
him.
me for calling my girl? I wasn't talking
Robert,
to my
stop
mom.
Stop
talking.
talking.
Let
What
me
is this
fix-
gonna help me with? They just
Stop-
raised my
stop
bond. I need to talk to
Stop
my mom.
talking. You're not helping yourself.
Call my girlfriend to have money brought here, dude.
okay. So
Yeah, I'm sorry. I was having really bad issues trying to get the rest of this clip this morning. I ended up having to shut everything down, load it back up, and continue it. So should
my
have
mom.
edited that out.
You're not helping yourself.
okay.
And we want it set for a full hearing. We're told that, and again,
All right.
I
I
believe
might
the
have.
mother's is the mother Claire.
No,
Oh.
5,000 cash surety. No 10%.
he has a right to have a bond hearing on this allegation.
And who are you going to have that hearing in front of, Counselor?
He wants to.
So I could have money brought up here. I
Robert,
need to talk to
stop
my mom.
talking. You're not helping yourself.
All right, this
Call
is
my
good enough.
girlfriend to have money brought here, dude.
Okay. So I am not denying your client a bond hearing. I am just reassessing his bond. His bond is being reassessed to 5,000 cash surety, no 10%. The other bond conditions are going to remain, which includes no contact with Robert Christopher Henley, no contact with Claire Henley, no contact with John Henley, no contact with Danetta Henley or any other witnesses. You were not returned to 415 Mack Avenue, East Lansing, or 4790 Mankato, MANKA.
You can call my girl, you're a faggot, bro. That's some gay shit.
Come back here.
Exactly. Exactly, dude. Like, why would you even fucking violate me for calling my girlfriend? You're just fucking.
I am going to order that the defendant have a GPS tether attached to him prior to his release, with a 2 to 3 mile hot zone, from the residence of 4709
All right,
Mankato,
that's- I'm not going to let him keep repeating that address. All right, that's about it. So he got to raise it from 3,000 to 5,000. It wasn't 10% for 3,000. It was cash or surety, and it's the same thing for the 5,000. And there's the GPS tether for calling his girlfriend. I'm guessing during the call he asked his girlfriend to contact his mom to bring up money. I'm guessing that's what happened. And that is a violation. But you can also see that cop or that police officer was not happy with that kid. So maybe he was rude to him, but he violated him quickly. Now, if he was polite to the police officer and he was talking, maybe the police officer would have been like, hey, you can't do that. Don't do that. I'm here. I can hear what you're saying. So I'm guessing that's what happened. But, or like I said, guessing that is what happened. Guy's doesn't seem to be the most polite guy. All right, that's all I got. Go watch your football. If you haven't already, like and subscribe. Do your jump kick backflips. If you would like to donate, I would very much appreciate it. Like I said, I spent a lot of time watching Colin putting these videos together, so you don't have to. It's like the Joe Dirt phrase that that multiple court watchers use. We watch the court, so you don't have to. We do the work, so you don't have to. Yeah, scrubbing bubbles, Joe Dirt. No, it's what they say. I don't say it, but it's still fun to say sometimes. All right, I'm rambling. Till next time. Bye.